Understanding medical, legal, and ethical issues is a critical component of becoming a competent emergency medical provider. This topic provides the foundation for making sound decisions, protecting yourself legally, and ensuring your patients receive ethical and professional care. In this brief overview, we will touch on the key principles that govern your responsibilities, such as scope of practice, standard of care, patient consent, and legal protections. However, it is essential to dive deeper into this subject by thoroughly reading your textbook, utilizing the lecture notes, and reviewing the PowerPoint presentation. These resources will provide you with a comprehensive understanding of the legal and ethical expectations you must meet as an EMS provider. Be sure to take notes, ask questions, and engage with the material, as this knowledge will guide you in real-world situations and help you navigate complex decisions confidently and ethically. A fundamental principle of emergency care is to do no further harm. This means that as an emergency medical provider, it is crucial to provide competent care while ensuring you act within your scope of practice. Adhering to the standard of care you were trained to deliver not only helps you provide the best possible treatment for your patients, but also protects you from potential civil or criminal liability. It is important to remember that even when care is rendered properly and in good faith, there is still a possibility that you may face a lawsuit from a patient seeking monetary compensation. Therefore, always focus on delivering skilled, appropriate care while maintaining professionalism and following established guidelines. Consent is a fundamental concept in emergency medical care, as it refers to the permission a patient gives to render treatment. Before providing care, a patient must provide consent. If a patient is conscious, rational, and capable of making informed decisions, they have the legal right to refuse care. The foundation of consent relies on decision-making capacity, which means the patient has the ability to understand and process the information provided and can make an informed choice regarding their medical care. At the heart of this principle is patient autonomy, or the patient's right to make decisions about their own health. To determine whether a patient has the capacity to make these decisions, several factors must be considered. Is the patient's intellectual capacity impaired by mental limitations or conditions such as dementia? Is the patient of legal age? Is the patient under the influence of alcohol, drugs, or affected by a serious injury or illness? Is the patient experiencing significant pain that could impair their judgment? Does the patient have any injuries that might distract them from recognizing a more serious condition? Are there hearing or visual impairments that could affect communication? Is there a language barrier preventing clear understanding? Does the patient appear to comprehend the information being shared? And do they ask rational questions that demonstrate understanding? Carefully assessing these factors helps you determine whether a patient can provide valid consent. Ensuring that patients understand their choices and respecting their autonomy is vital in delivering ethical and legally sound care. Expressed consent occurs when a patient clearly acknowledges that they want you to provide care or transport. This type of consent can be verbal, nonverbal, or written, but it must be explicitly given. For expressed consent to be valid, it must also be informed consent. This means that you, as the provider, have explained the nature of the treatment being offered in a way the patient can understand. When obtaining informed consent, you must clearly communicate the nature of the treatment or care being provided, the potential risks and benefits of the treatment, any reasonable alternatives to the proposed treatment, and the possible consequences of refusing treatment. By ensuring the patient has all the necessary information to make an informed decision, you respect their autonomy and fulfill your legal and ethical obligations as an emergency medical provider. Implied consent is a legal principle that allows emergency medical providers to render care when a patient is unable to give expressed or informed consent. This typically applies to patients who are unconscious or otherwise incapable of making a rational, informed decision about their care. Implied consent is only valid when a serious medical condition exists and there is a threat to life or limb. It should never be used unless the patient's condition warrants immediate intervention to prevent harm. This principle is also referred to as the emergency doctrine, as it assumes that a reasonable person in such a situation would consent to life-saving care if they were able to do so. Whenever possible, it is important to try to obtain consent from a spouse or a relative before proceeding with care under implied consent. However, in true emergencies where there is no time to delay treatment, the patient's safety and well-being take precedence, and care should be provided promptly. Involuntary consent applies to patients who are unable to provide informed consent due to specific conditions such as being mentally ill, experiencing a behavioral psychological crisis, or being developmentally delayed. In these situations, consent should be obtained from a legal guardian or conservator whenever possible. However, it is important to recognize that obtaining such consent is not always feasible, especially in emergencies where immediate care is required. To address this, many states have protective custody statutes that allow individuals in these circumstances to be taken to a medical facility under the authority of law enforcement. These laws are in place to ensure that patients who may be a danger to themselves or others receive the necessary care while maintaining legal and ethical protections for the EMS provider. Minors and consent involve specific legal considerations as minors. Individuals under the legal age generally cannot provide consent for their own care. In most cases, consent must be obtained from the parent or legal guardian. However, there are exceptions in some states where minors are legally allowed to give consent. These include situations involving emancipated minors, who are individuals under the legal age but are legally considered adults. Minors may be deemed emancipated if they are married, members of the armed services, parents themselves, or living independently and no longer relying on their parents for financial support. In certain settings, such as schools or camps, teachers and school officials may act in loco parentis, in place of parents, to provide consent for treatment of injuries that occur while the child is under their care. If a true emergency exists and consent from a parent, legal guardian, or authority figure is unavailable, you may provide treatment under the principle of implied consent. In these situations, the focus should remain on the child's immediate medical needs to prevent further harm or life-threatening complications. Forcible restraint is sometimes necessary for patients who need medical treatment and transportation but are combative and pose a risk of harm to themselves or others. While it is legally permissible, certain steps must be followed to ensure the safety of everyone involved and to protect yourself legally. First, always consult medical control for authorization before restraining a patient, and make sure law enforcement is present on the scene to assist. Remember that restraining a patient without legal authority can result in civil and criminal penalties, so it's crucial to be familiar with local laws and protocols surrounding forcible restraint. Once restraints are applied, do not remove them during transport unless they create a significant risk to the patient. If the patient remains severely combative or dangerous, consider requesting ALS backup to provide chemical pharmacologic restraint for additional safety and control. Adults who are conscious, alert, and appear to have decision-making capacity have the right to refuse treatment, even if that decision could lead to serious injury or death. Additionally, they can withdraw from treatment at any time, regardless of the potential consequences. Because refusal of treatment is a highly sensitive issue and one that is commonly litigated in EMS, it is critical to strictly follow local protocols and policies when handling such cases. Always involve online medical control to confirm the patient's decision and ensure that proper steps are taken. Finally, thorough documentation of the consultation with medical control and the patient's refusal is essential to protect yourself and your agency from legal challenges. A patient's, parents', or caregiver's decision to accept or refuse treatment should always be based on clear and thorough information provided by you, the EMS professional. This includes your assessment of what might be wrong, a description of the treatment you believe is necessary, the possible risks of that treatment, any available alternative treatments, and the potential consequences of refusing treatment. If treatment is refused, it's essential to assess and document the patient's ability to make an informed decision. This involves asking and repeating questions, carefully evaluating the patient's responses, and observing their behavior for signs of understanding and coherence. Keep in mind that if the patient appears confused, delusional, or suicidal, you cannot assume their decision to refuse treatment is informed. In such cases, additional steps, including consultation with medical control, may be necessary to protect the patient's well-being. When in doubt, providing treatment is generally a more defensible position than failing to provide care to a patient. However, your safety must always come first. Do not endanger yourself to provide care under any circumstances. If the situation becomes unsafe or the patient is uncooperative, enlist the assistance of law enforcement to ensure your own safety and the safety of those around you. Remember, your ability to remain safe and capable is critical to delivering effective care. Before leaving the scene where a patient, parent, or caregiver has refused care, it is critical to take certain steps to ensure they are informed and protected, and that you are documenting the encounter appropriately. First, always encourage the patient, parent, or caregiver to permit treatment and remind them that they can call 911 again if they change their mind or if the condition worsens. Additionally, advise them to contact their physician as soon as possible for further evaluation. Next, request that they sign a refusal of treatment form. Ensure that a witness is present during this process, which adds an additional layer of protection for all parties involved. Finally, be sure to thoroughly document all refusals, including the patient's condition, your recommendations, and their decision to refuse care. This detailed documentation is crucial for both patient safety and legal protection. Confidentiality is a fundamental aspect of patient care. Any communication between you and the patient is considered confidential, meaning it should not be shared without proper authorization. This includes sensitive information such as the patient's history, your assessment findings, and the treatment provided. If you release this information inappropriately, you may be held liable for a breach of confidentiality, which involves disclosing patient information without the necessary authorization. In most states, patient records may only be released under specific circumstances. If the patient signs a release form, if a legal subpoena is presented, or if the information is required by billing personnel. It's crucial to follow these guidelines to protect the patient's privacy and ensure legal compliance. Confidential information includes critical aspects of patient care, such as their history, assessment findings, and the treatment provided. Improperly releasing this information without authorization can result in a breach of confidentiality, which carries significant legal consequences. The Health Insurance Portability and Accountability Act of 1996, or HIPAA, plays a vital role in safeguarding patient privacy. HIPAA strengthens privacy laws and provides clear guidance on which types of information are protected, the responsibilities of healthcare providers in maintaining that protection, and the penalties for breaching confidentiality. Under HIPAA, all patient information obtained during medical treatment is classified as Protected Health Information, or PHI. This includes medical data and any information that could identify the patient. Adhering to HIPAA guidelines is crucial to ensuring patient trust and compliance with the law. Failure to comply with HIPAA regulations can have serious consequences, including civil and even criminal actions against you and your agency. This underscores the importance of understanding and adhering to HIPAA guidelines at all times to protect patient information. It's important to note that the general public is often permitted by law to record identifying and protected patient information or images. While this may be outside your control, you must remain vigilant in ensuring that you, as a healthcare provider, do not contribute to any breaches of confidentiality. Your actions should always prioritize the security of patient data and compliance with HIPAA standards. Social media can be a powerful tool, but it must be used responsibly, especially in the context of your role as an EMS professional. If you are not operating as an official spokesperson for your agency, avoid using logos, uniforms, vehicles, or other identifiable markings that link you to your agency while off duty. Always conduct yourself with the same level of professionalism online as you do while on duty. Remember to respect your patients, their friends and family, bystanders, colleagues, and your organization, both in person and in the online space. Lastly, while free speech is a right, it is not absolute. Understand that your words and actions online can have repercussions, and it's essential to maintain professionalism and discretion in all social media interactions. Advanced directives, such as a Do Not Resuscitate DNR order, can guide your response when you encounter a patient who is dying from an illness. A DNR order provides permission to withhold resuscitation efforts if the patient goes into cardiac arrest. However, it is crucial to understand that do not resuscitate does not mean do not treat. Even in the presence of a DNR order, you are obligated to provide supportive care, such as oxygen administration, pain relief, and comfort measures, as long as the patient is not in cardiac arrest. Every ambulance service should have clear protocols for managing situations involving advance directives. Familiarity with these protocols ensures that you provide appropriate care while respecting the patient's wishes. Advance directives are written documents created by competent patients to specify their medical treatment preferences if they become unable to make decisions. These documents are most commonly used when a patient becomes comatose and are often referred to as a living will or healthcare directive. For a Do Not Resuscitate or DNR order to be valid, it must meet specific requirements. These include a clear statement of the patient's medical condition, the signature of the patient or their legal guardian, and the signature of one or more physicians or licensed healthcare providers. Additionally, if the DNR order has an expiration date, it must be dated within the preceding 12 months to remain valid. Understanding these requirements ensures that advance directives are properly honored and legally upheld. When caring for patients with terminal illnesses, you may encounter physician orders for life-sustaining treatment, or POLSD, and medical orders for life-sustaining treatment, or MOLSD. These forms serve as medical orders that clearly define the acceptable interventions for the patient's care. To be valid, these orders must be signed by an authorized medical provider, ensuring that they reflect the patient's wishes and meet legal requirements. If you encounter these documents during your care, it's essential to contact medical control for guidance. This ensures that you follow the orders appropriately while maintaining alignment with medical protocols and the patient's needs. Some patients may appoint surrogates to make medical decisions on their behalf, particularly when they are unable to do so themselves. These surrogates are often designated through durable powers of attorney for healthcare, also known as healthcare proxies. These legal documents allow patients to ensure their medical wishes are followed, even if they cannot communicate them directly. With the growing prevalence of hospice and home health care programs, you are increasingly likely to encounter situations where a surrogate or proxy is involved. Understanding their role and ensuring their decisions align with the patient's wishes and legal documents is an essential part of providing compassionate and compliant care. The determination of the cause of death is a medical responsibility that falls solely on a physician. However, as EMS providers, you may encounter presumptive signs of death that indicate the patient is no longer alive. These presumptive signs include unresponsiveness to painful stimuli, the absence of a carotid pulse or heartbeat, the lack of chest rise and fall, and no deep tendon or corneal reflexes. While these signs are strong indicators, it is essential to remember that a definitive determination of death must be made by a physician. Continuing with the presumptive signs of death, additional indicators include the absence of eye movement, the lack of systolic blood pressure, and profound cyanosis, which is a bluish discoloration of the skin caused by a lack of oxygen. Another sign is a lowered or significantly decreased body temperature, which reflects the cessation of the body's metabolic processes. While these signs strongly suggest death, remember that the final determination must still be made by a physician. Definitive signs of death are those that leave no doubt that the patient has passed away. These include obvious mortal damage, such as decapitation, which is incompatible with life. Another definitive sign is dependent lividity, which occurs when blood settles to the lowest point of the body after death, causing noticeable discoloration of the skin in those areas. These signs confirm death and do not require further resuscitative efforts. Continuing with the definitive signs of death, we observe key physiological changes that confirm death. Rigor mortis, or stiffening of the body, typically occurs between 2 to 12 hours after death as the muscles contract and then stiffen. Algor mortis refers to the cooling of the body until its temperature matches the ambient environment. This process begins immediately after death and continues over time. Lastly, putrefaction, or decomposition, occurs between 40 to 96 hours after death. It involves the breakdown of tissues, often accompanied by distinct physical changes and odors. These signs help in establishing a definitive conclusion that resuscitative efforts are no longer appropriate. The involvement of the medical examiner depends on the nature and scene of the death. In most states, the medical examiner or coroner in some states must be notified in specific situations. These include cases where a patient is dead on arrival (DOA), sometimes referred to as dead on scene (DOS). Notification is also required for deaths occurring without prior medical care or when the physician cannot determine the cause of death. Other scenarios include deaths resulting from accidents, suspicion of a criminal act, or cases involving infant and child deaths. Additionally, the medical examiner must be contacted in cases of suicide, violent deaths, or known or suspected poisoning. Understanding these requirements ensures proper reporting and compliance with legal standards. Standards of care refer to the manner in which you must act or behave while performing your duties as a healthcare provider. It serves as a guideline for your actions and decisions in various situations. This concept is defined as how a person with similar training and expertise would act under comparable circumstances. Adhering to the standard of care ensures that your actions align with professional expectations, promoting safe and effective patient care while minimizing liability. Standards of care are not arbitrary. They are established through various authoritative sources to ensure consistency and quality in medical practice. First, local customs often play a role in defining acceptable practices within a specific community or region. Laws, including statutes, ordinances, administrative regulations, or case law, provide a legal framework for standards of care. Professional or institutional standards, such as the American Heart Association's CPR guidelines, further define expectations for healthcare providers. Lastly, educational resources, like textbooks, such as those published by the National Highway Traffic Safety Administration (NHTSA), offer evidence-based guidelines to support best practices. Understanding these sources ensures your actions align with both professional expectations and legal requirements. Standards of care are further established by the requirements and regulations imposed by states. These include frameworks such as the Medical Practices Act, which outlines the legal scope of medical care. Additionally, certification, licensure, and credentialing processes play critical roles in ensuring that healthcare providers meet the necessary qualifications and maintain professional competency. These state-imposed standards are designed to protect patient safety and uphold the integrity of medical care. The duty to act is an individual responsibility for providing patient care. This duty becomes legally binding once your ambulance responds to a call or you initiate treatment for a patient. At that point, you are obligated to continue care as part of your professional responsibility. However, In most cases, if you are off duty and come across an incident, such as a crash, you are not legally required to stop and provide assistance. It is essential to be familiar with your local laws and organizational policies regarding your duty to act, as they may vary and directly impact your obligations in specific scenarios. Negligence is defined as the failure to provide the same level of care that a person with similar training would provide in the same or similar situation. It is a critical concept in EMS, as it outlines the responsibilities and expectations placed on healthcare providers. For the legal doctrine of negligence to apply, four specific factors must be present. First, duty. This refers to the obligation to provide care in a manner consistent with the standard of care established by your training and local protocols. Second, breach of duty. This occurs when an EMT fails to act within the expected and reasonable standard of care. Third, damages. This means the patient suffers noticeable harm, either physical or psychological, as a result of the care or lack thereof provided. Lastly, causation. There must be a clear cause and effect relationship between the breach of duty and the harm experienced by the patient. Understanding these elements helps EMTs act responsibly and avoid situations that could lead to allegations of negligence. Let's expand on some additional legal concepts related to negligence and liability in EMS. First, residential ipsa loquitur, a Latin term meaning the thing speaks for itself. Under this theory, an EMT can be held liable if it can be shown that an injury occurred. The cause of the injury was under the EMT's control, and such injuries typically do not happen without negligence. Next, negligence per se applies when the conduct of the individual being sued is alleged to have clearly violated a statute. For example, an EMT performing an advanced life support skill they are not trained or authorized to perform, resulting in injury, would be considered negligence per se. Finally, we have torts, which are civil wrongs not governed by criminal law. Torts are handled in civil court and include cases such as defamation of character or invasion of privacy. These situations can arise in EMS when the actions of a provider harm a person's reputation or violate their personal rights. Understanding these legal principles is crucial for practicing within the scope of your duties and protecting yourself from liability. Abandonment occurs when an EMT unilaterally terminates care for a patient without the patient's consent and without ensuring that care is handed off to another competent medical professional. This is a serious legal and ethical violation in EMS. Once you initiate care, you assume a duty to act that must continue until an equally qualified medical provider takes over the patient's care. Abandonment can happen either at the scene or at the emergency department where you are transferring the patient. To avoid abandonment, it's essential to ensure a proper transfer of care. When transferring a patient at the hospital, always obtain a signature on the patient care record from the individual accepting responsibility for the patient. This step not only ensures continuity of care, but also protects you legally. In EMS, understanding the legal implications of assault, battery, and kidnapping is critical to maintaining ethical and legal standards in patient care. Assault occurs when you unlawfully place someone in fear of immediate bodily harm. For example, threatening to restrain a patient who does not want to be transported could be considered assault. Battery involves unlawfully touching another person. This includes providing emergency care without obtaining the patient's consent, even if the care is intended to help. Kidnapping is defined as seizing, confining, abducting, or carrying someone away by force. In EMS, this could occur if a patient is transported against their will. Related to this is false imprisonment, which is the unauthorized confinement of a person without proper justification. Legal problems can arise if a patient has not given consent or decides to rescind consent for treatment or transport. Always respect the patient's rights, obtain proper consent, and document everything to avoid potential legal consequences. Defamation occurs when false information is communicated in a way that damages a person's reputation. There are two types of defamation to be aware of. Libel refers to written defamation, such as a false statement entered into a patient care report. Slander refers to spoken defamation, such as making inappropriate comments about a patient during casual conversation, like a station house discussion. To avoid defamation, ensure that all statements in your run report are accurate, relevant, and factual. Maintaining professionalism and adhering to the facts protects both the patient's reputation and your own credibility as a provider. Good Samaritan laws are designed to protect individuals who provide reasonable assistance to others in good faith. These laws aim to ensure that someone offering care in an emergency is not held liable for errors or omissions made while rendering care in good faith. To be protected under these laws, several conditions must generally be met. You acted in good faith while providing care. You offered assistance without expecting compensation. You stayed within your scope of practice. You avoided acting in a grossly negligent manner. Gross negligence refers to conduct that demonstrates a willful or reckless disregard for a duty or standard of care, which falls outside the protections of Good Samaritan laws. Additionally, immunity statutes may apply to EMS systems operating as governmental agencies. Sovereign immunity limits liability but does not provide complete immunity. This underscores the importance of adhering to professional standards and acting responsibly when providing care. Most states require healthcare providers and emergency responders, including EMTs, to fulfill certain mandatory reporting obligations. These obligations are in place to ensure that specific incidents are appropriately documented and addressed. The specific mandatory reporting requirements may vary by state, but typically include cases of child abuse, abuse of an older person, or abuse of other at-risk adults, injuries that occur during the commission of a felony, drug-related injuries, where substances may have played a role in the patient's condition, instances of childbirth, especially in non-traditional or emergency settings. Familiarity with your state's mandatory reporting laws ensures that you meet these obligations while providing care and protecting vulnerable individuals. In addition to the previously mentioned cases, most states have a mandatory reporting obligation for other critical situations, which include attempted suicides, to ensure individuals receive appropriate intervention and mental health care, dog bites, which may require public health involvement for rabies prevention and animal control, communicable diseases, to monitor and control the spread of infections within the community, assaults, to document and potentially investigate acts of violence, domestic violence, to protect victims and connect them with resources and support services. These reporting requirements are vital for ensuring public safety, addressing potential threats, and providing necessary care and resources for affected individuals. In addition to the previously discussed mandatory reporting requirements, there are further scenarios where reporting is often required by law. Sexual assault or rape. These cases must be reported to ensure victims receive appropriate medical care, counseling, and legal support. Exposures to infectious disease. Reporting helps protect public health and enables timely interventions to prevent disease spread. Transport of patients in restraints. Documenting these situations ensures transparency and proper handling of individuals in custody or under medical care. Scene of a crime. Reporting ensures that evidence is preserved and law enforcement is informed for further investigation. The deceased. Reporting deaths allows for proper legal and medical documentation and any necessary investigation. These obligations are critical in promoting safety, justice, and proper care while ensuring compliance with state regulations.